Yeah, for whatever reason, it stopped. So you just carry on from where we were. So if you're going to use the military grid thing, you put it in brackets, and then I will deem service by any other means as defective. Such correspondence will receive no recognition without dishonor on my part. As shall any correspondence whose direction is at a nom de guerre, I think we all know what a nom de guerre is by now, is a civiliter mortus, is a dead civilian with no rights, okay, with the style or title of Mr., Mrs., Miss. All those titles are legal fiction, nom de guerre, name of war, legal titles that you need to get away from. As long as you identify yourself as a Mr. or Mrs., you lose all your natural rights because your mother never called you a Mr. when they born you. When they born you. They never called you a Mr. or Mrs. Who created a Mr. or Mrs.? And who wants you to be a Mr. or Mrs.? It's somebody who has a financial interest in you being a Mr. or Mrs. or acting as a Mr. or Mrs. So you're not going to do that. Right. And then finally, you need to decide the language of the agreement and the governing of the agreement. Those two things. So this particular one was constructed in maritime jurisdiction upon a base of the proper grammatical rules of the English language, and we use manuals, Oxford and what's the other one? Chicago and Black's Law. But now that we've created our own dictionary, we don't quote this anymore. We just say that we have a dictionary attached to this. Definitions, not definitions, dictionary or glossary of terms, because it's not a definition. We're not definitions. It's a dick. So we're going to give you a big fat dictionary at the back of the document. All right, get it? All right, and then finally, the governing of the agreements. You need to understand that agreements can be governed by any law of the parties. It's private. You can decide to that the governing of your mortgage agreement is under Sharia law if you wanted. You see, you can decide that between the two of you. Doesn't matter. So the governing of this particular agreement was through arbitration. So we're not going to go to civilian courts, which are rigged by crooks, right? Somebody called a dick judge, somebody whose back is as crooked as a dog's hind leg is called a district judge, and you can find him in a magician's court. Those characters, so you don't want to get into those venues. Those are magicians. Anybody wearing black robes and cloaks, you want to keep away from them. So this particular agreement, the governing is through arbitration and is in concordance with the equitable principles of fairness. So it's a code of equity, right? Under the landmass known as England, all right? So that's the governing of the agreement. And if it goes beyond, and if it cannot be resolved there, then the only court you'll go to resolve it is the International Court of Justice. That is it. You don't go to a county court or a magician's court to resolve judicial matters. Those are administrative, all right? Period. This is my free will act and deed on this 19th of September, whenever it was. Then you resolve all your natural rights. If you're attorney in fact for the corporation of, you put your a strawman appellation, you put your proper appellation above it, so they know that you're not standing as surety for the corporation. You a representative. As long as you're a representative, you're not held liable. A representative is like a lawyer. So you're representing this corporation called your strawman. That's all you're doing. You do not stand as surety for it. You didn't create it. But once in a while you represent it in order to create finance for the perpetual national debt. To allow the bankers to live, once in a while when you feel like it, you use that name for business. But it's not you. You're not a name. You're a living soul. Never be a name. Okay, so that's conditional acceptance. Straightforward, man. ABC. How easy is that? And that's a long version. So I don't know what else. There's nothing else. I mean, you don't have to write all this stuff. You don't have to go in 3 pages. You can do a conditional acceptance in 1 page, depending on the instrument they've sent you. However, the point is that you have to deal with each individual instrument, and you have to deal with the issues that they raise. So you can not ignore the issues and raise controversy. So if the issue they raise is we want to come and see you on this date, that is the thing that you deal with. We have to create conditions around them coming to see you, that's all. But if you ignore that or argue with it, boom, you're in commercial dishonor. They're going to say, oh, she refused for us to go and see her. And then the bank and the fake court will carry on doing what they do. Invite them in. They want to play? Let's play. You want to act? Let's act. So conditional acceptances, 4 headings. Number 1, notice of conditional acceptance. Number 2, statement of facts. Number 3, memo of law, use maxims. You can use statutes if you're very good at them. You can use statutes, no big deal. And notice of fault and counteroffer. So if you don't give me the paperwork I need to satisfy or pay the claim, settle the claim, you're impeding settlement. You're in dishonor. What's wrong with you? Do you want the money or not? Alright? A, B, C. How easy is this stuff? Baby. Alright? So you stick it to black. Stick it to black in it. On your stank ass.